Thanks, Ceann Comhairle. Minister, I don't actually believe, as has been alleged by one of the contributors, that abortion is the divisive issue that it once was. I think many people in Irish society have very different views on the subject, as is their right, but they would also recognise that it is a private matter, a health matter, and one for the woman, primarily herself, and that of her doctors. I think that repeated opinion polls have revealed the fact that the overwhelming majority of Irish citizens support the need for legislation for abortion where a woman's life is in danger, where she has been raped and impregnated as a result of that rape, in cases of fatal fetal abnormalities, and in cases of where a suicide risk occurs. Many citizens also recognise that that choice should be the woman's, no matter what those circumstances are. Now, I'm aware that because of the constitutional restrictions, it wouldn't have been possible for your government to legislate for all of those circumstances. But I have to say that you could have done a lot more, even within the confines that you have now. And I don't agree that this legislation actually does provide the legal clarity that's necessary. I don't believe that it makes the situation safer for women. For me, it really is the absolute minimum that you could kind of get away with to, in part, satisfy the European Council of Human Rights and also pacify some government backbenchers. And for me, not really your party, but actually I think the deep irony here is that the Labour Party, who when we moved our legislation previously, criticised us for not going far enough and told us that they couldn't support our legislation because it didn't make enough provision, are now putting forward this legislation which could have gone further even within the constitutional restrictions. Now, other deputies have explained why we're here. Successive governments have failed to legislate for the X case, providing for abortion where there was a real and substantial risk to the life of a woman, as has been the legal position in Ireland for decades. But because it wasn't legislated for with an act to back it up, no woman could really avail of that provision. I don't think that this legislation clarifies the situation enough. In fact, the point made by the Chief Justice in the X case ruling that the risk need not be immediate or inevitable actually hasn't been addressed in this bill at all, and that is something that could have given greater clarity. I think that we've had a lot of discussion over the past period in the media and indeed inside, where a lot of the talk really has been a false debate. It's as if what we're discussing here is a way of minimising or restricting abortion in Ireland or providing for abortion in Ireland. The reality is that Irish abortion exists. We just have a hypocritical situation where we provide for that legally. A woman has an absolute legal right to have an abortion if she's Irish by enshrining her right to travel, but we just don't allow her to have it here at home. And I don't think that's good enough. I think that's a denial of the rights of the over 150,000 Irish women who've been forced to leave these shores over the past number of decades. All of the reasons why those women had to travel, and none of them were easy, all of them were valid in my opinion. And the problem here is that against the backdrop of increased austerity, the option to travel is going to be removed from many women who are on low incomes, and obviously will be jeopardised to women who are from non-national backgrounds. And I would look at this debate from a starting point of it being one of basic human rights and basic health issue. Now, it isn't your fault, Minister, in some ways that this bill is as limited as it could be. The problem rests with our inadequate constitution, a constitution which your colleague, the Minister for Justice, previously characterised as ensuring that not all our citizens are treated equally. Our constitution means that while there are no impediments to medical treatment for men when their health is in jeopardy, that for women that is a qualified right and means that some citizens are not equal to others. I don't think that's good enough. It's my belief that the 8th Amendment should be repealed. It is something that we have called for and will be pushing for beyond this, but I realise that you're operating within the confines of the Constitution as it stands, and I want to maybe refer to some points in that regard, which we'll obviously tease out later on. at committee stage through amendment, because this bill has got serious problems in it. It criminalises women and doctors, and the restrictions in it, in my opinion, will continue to put the lives of women and girls at risk, and that's something that we cannot stand over, and we will be moving a huge amount of amendments. I think there is an enormous problem with the fact that it continues to pose abortion as a criminal offence, with a fine of up to 14 years for women, for doctors, including those who would use abortion pills to end an unwanted pregnancy. It does raise the spectre that a woman who presents herself as suicidal and seeks an abortion could potentially face an imprisonment period longer than the perpetrator of her rape would actually endure. This is just not good enough. This legislation brands thousands of Irish women as criminals. They have to sneak away or secretly get abortion pills. And in that sense, it doesn't eliminate the chilling effect which was described by the European Court of Human Rights, where women are seeking to get this treatment. It will deter women from seeking aftercare where they've used abortion pills or where they go abroad to seek an abortion. And criminalisation, as we know, will not reduce the abortion rate. It simply puts women and girls' lives at risk, and that is something that we will certainly be calling for an amendment on. It's not good enough at all that that remains. I think as well we'd have to say that it doesn't overcome the difficulties outlined in the case of Savita Halappanavar and highlighted in the HSE report, where it was quite clear that under law, as one of the consultants said, if there's no evidence of risk to the life of the mother, our hands are tied as long as there's a fetal heartbeat. Now that is a problem that is being enshrined in this legislation as well, because what we're seeing is that medical conditions due to pregnancy that are not in and of themselves life-threatening, say a miscarriage or, for example, must be allowed to become life-threatening before a woman can get the necessary termination of pregnancy to be legal. And we have the scenario then of medical practitioners having to stand over a wait-and-see scenario of their patients' health deteriorating to the point where their life is in danger before the matter can be addressed. I think one of the issues that your own expert group dealt with was that under any circumstances the opinion of only 2 medical practitioners should be sufficient. We went to the trouble of convening an expert group. That was their call on the matter for either mental health issues or medical issues, and yet this bill puts a requirement for up to 4 practitioners in it: an obstetrician, 2 psychiatrists and possibly the woman's own GP. They have to examine the woman, they have to agree that she's suicidal and so on. There's no doubt that this is going to deter despairing women from even asking for an abortion in Ireland, especially when they have to face that type of tribunal. It will drive them further overseas, and to me, I don't think that that is good enough, and we could have done more. One of the biggest problems with this bill is the definition of the unborn. And, you know, I think government deputies really have to examine this matter. We've all been struck by the tragedy of the families who have come forward with their very difficult stories of their cases where their fetus had a fatal abnormality, and how those people had to endure the torture of either being faced with bringing that pregnancy to full term, with all of the questions: when are you due, how are you getting on, and all the rest of it, or go to England like outcasts. I don't think that the existing legislative provision could have allowed you to provide for cases of fatal fetal abnormality, and you haven't done it. That cannot be allowed to stand. Not only have you not done it, but by defining unborn human life, as you propose to do in this legislation, as existing from the moment of implantation in the womb until delivery, and giving that an equal right to life as the woman or the girl, you're removing the very possibility of legislating to deal with fatal fetal abnormalities. You're closing off the D case ruling, where the state argued that a fatal fetal abnormality could be the grounds for a termination, even within the confines of the Constitution. This is a cruel blow to the 1,500 women and couples who face this situation every year, and as an absolute minimum, this part of the bill has to go. Minister, I think we will have a debate over the next period. It is important that this bill is before us. I'm glad we have some legislation, but it could have been a lot better, and we'll hopefully be amending it to ensure that it is.
Thank you, Deputy.